Good morning and welcome to this Legal Aid New South Wales webinar, Apprehended Domestic Violence Orders. We would like to firstly acknowledge the traditional owners of the lands from which we're broadcasting today. I'm broadcasting from the land of the Widjabul-Waible people of the Bundjalung Nation, and Julia is broadcasting from the land of the Gadigal people of the Eora Nation. We pay our respects to the elders of these lands, past and present, and extend that respect to any First Nations people attending today's webinar or watching the recording. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. The session will be an hour, including time for questions towards the end. After the webinar, you will receive an evaluation survey and we do value your feedback and take it on board. You'll also receive an email with information about any resources that we talk about during the webinar today. We will be referring to the law in New South Wales in today's webinar and to services available in New South Wales. If any of you are joining from another state, these laws will not apply to you and the laws in your state may differ and available services may differ as well. I'll now hand over to your presenter for today's webinar, Julia Brown, solicitor in Legal Aid's Domestic Violence Unit. Welcome, Julia.
Thanks, Bridget. And thanks everybody for joining us today. My name is Julia Brown and I am a solicitor with the Domestic Violence Unit at Legal Aid. In the DVU, we work with people who have and are experiencing violence. Before we get started today, I would like to mention if anyone finds this content confronting or distressing, please feel free to take a break or to get in contact with me after the session. So today's webinar is on apprehended domestic violence orders, and we will cover what is domestic and family violence, what is an AVO, when are AVOs made, what conditions are available on AVOs, and what can you do or your client do if your AVO is breached. So I thought we'd start by talking about what is domestic and family violence. I know that a lot of you would have experience in this area, but I thought it might be a good idea for us to start from a shared understanding. There are also slightly different legal definitions of domestic violence in the Family Law Act, for example, in migration law, than what actually constitutes a domestic violence offence in New South Wales in criminal law. In the DVU, we work from the definition of domestic violence occurring when a person exercises power and control over another person. It involves coercive and abusive behaviours that are designed to intimidate, humiliate, undermine and isolate, and it results in fear and insecurity. It covers a wide spectrum of conduct and it doesn't all have to be physical. And although every experience is unique, domestic and family violence is not a one-off incident for most people. It is a pattern of power and control that can happen over a long period of time. So I've got some examples here of what domestic violence, domestic and family violence can include. This is not all of the different behaviours, but some examples. So physical abuse can be hitting, pushing, choking, pulling hair, making a person take drugs or alcohol, damaging property. Sexual abuse can be unwanted touching or kissing, forced sexual acts. Psychological abuse can include social isolation, which is quite a common one that we see. Name calling, derogatory taunts, intimidation, threats to self-harm, gaslighting, controlling someone's movements, harassment and stalking. And then financial abuse, which can include preventing someone from working, only giving small allowances or making someone beg to meet their daily needs, forcing a person to sign documents or take on debts. Our next slide you might be familiar with. It's the Duluth Power and Control Wheel. This looks at non-physical forms of domestic and family violence. It's a useful tool for understanding non-physical tactics of power and control that might be used to keep a person in a situation of violence. Someone might be experiencing domestic and family violence but may not realise or identify as experiencing domestic violence. So it can be a useful tool for practitioners and people to identify what's going on in their relationship. And when we look at intimate partner homicide in Australia, actually the most frequent identified abuse was emotional and psychological abuse, such as verbally denigrating or threatening or blaming or gaslighting a victim. And physical violent behaviours were the second most frequent identified type of abuse. So I think it's important to remember that there is a wide range of behaviours that can constitute domestic and family violence. And when we're working with clients, it's important to have an understanding of what is going on in someone's relationship. So in our next slide, we look at a few statistics around domestic and family violence in Australia. So men do experience violence as victims. However, the statistics show us that the majority of people who use domestic and family violence are men, and the majority of victims are women. Men are most likely to experience violence by a male stranger in a place of entertainment, while women are most likely to have experienced violence perpetrated by a known male in the home. The most recent ABS statistics show us that 1 in 4 women have experienced physical or sexual violence by a male partner. This is compared to 1 in 14 men who have experienced physical or sexual violence by a female partner. And these statistics don't actually take into account non-physical forms of domestic violence. Women are also more likely than men to experience stalking. 20% of women have experienced stalking, and 6.8% of men have experienced stalking. 3/4 of all reported cases of intimate partner homicide have involved a male offender killing a current or former female partner. And in the majority of cases which involved a female offender of intimate partner violence homicide, the female offender was also the primary victim of domestic violence who killed her male abuser. So domestic and family violence has a gendered nature to it. On the next slide, we've looked at the social cycle theory. This is a diagram that Lenore Walker's socials that developed in 1979, and it explains the cyclical sort of phase of violence that many women and other victims experience in a domestic and family violence relationship. So I think it's important to note it's not every person's experience, but and violence comes in many shapes or forms, but it can be useful when working with people who experience violence to understand where they might be at if, for example, a perpetrator is in the stage of remorse. Research suggests that they might be more willing to uptake a referral because of a desire to change, which can affect the likelihood of reoffending. So now we'll move on to what is an apprehended violence order. So an AVO, or apprehended violence order, is an order made by a court which imposes conditions aimed to protect a person, also known as the protected person or the person in need of protection, from another person who's the defendant. An AVO is sometimes called an intervention order or a restraining order, a protection order, or a domestic violence order or a family violence order. It depends on what state and territory the order was made or what jurisdiction. The research shows that in most cases, AVOs actually do have a significant effect on reducing or eliminating violent and negative behaviours. That was found by a boxer in an evaluation of the New South Wales AVO scheme. In terms of, there are types of AVOs, there are two types of AVOs in New South Wales: an apprehended domestic violence order, and that is made when the people involved are related, living together, or in an intimate relationship, or they have been previously in this situation. In the case of Aboriginal and Torres Strait Islander people, ADVOs can be made where the people involved are part of the same kin or extended family. And then we've got an apprehended personal violence order. And this is made where people involved are not related and do not have a domestic relationship. So, for example, a neighbour or a work colleague. Okay. So now we've got a poll question. So if police have not applied for an apprehended violence order on behalf of a victim of violence, can the victim apply for their own AVO? So if you can indicate if you think people can apply for their own, tick yes. And if you think that they can't, tick no. And we'll have a look at what the results are. Great. So 94% of respondents answered yes, people can apply for their own apprehended violence order if the police don't take out an order for them. And that is correct. So often the police in New South Wales apply for the vast majority of AVOs in New South Wales. They apply for over 95% of AVOs. But a victim can apply for an AVO by making a private application to the local court registry. And the Women's Domestic Violence and Court Advocacy Service will often support a woman who would like to do this, or a legal aid domestic violence lawyer can also assist in drafting the application. There are differences between when a police applies for an AVO and when a private applicant makes an application for an AVO, and we'll talk about some of those differences now. When the police apply for an AVO, it will be the police's decision to apply for the AVO and not the protected person. I think this is a common misconception with people that we work with, that the police are often listening and considering the protected person's point of view, but they are ultimately making their own decision about whether or not to apply for an apprehended domestic violence order. And sometimes, even if a protected person does not want the AVO, in many circumstances, the police will apply for one anyway. The police guidelines require an officer often to apply for an AVO when they're responding to a domestic violence incident. If the police make an AVO on a protected person's behalf, then the police prosecutor will seek the order in court. This means that the protected person won't have to attend all of the court dates, whereas if a private application is made for an AVO, the person who is applying or their legal representative will have to attend court to seek this order. If someone is eligible for legal aid based on their financial circumstance, then legal aid may be available to applicants in AVOs. Legal aid is also available to defendants in cross applications for AVOs. So when there are an AVO against both parties in the matter, in many circumstances. And this is designed to protect victims of violence who are subject to AVOs because of defensive violence or because a person has applied for a cross AVO in an attempt to intimidate or retaliate against the victim. And we often see this in our local court work. People who want advice about AVOs can get some initial advice from us at the DVU regardless of their financial circumstance. And I would encourage you to refer these clients to us, even if they have been told by police that they can't get an AVO. It's important that, that people applying for an AVO understand the process if they are intending to apply on their own, because it can be a lengthy process and protections are not in place immediately once the other party is served with a copy of the AVO, like in a police application. So when are apprehended violence orders made? An AVO can be made when the court is satisfied of three things. So firstly, the person has reasonable grounds to fear the commission of an offence or engagement in conduct of the other person which is intimidatory. And so this is an objective test. So would a reasonable person standing in their shoes also fear the commission of a domestic violence offence? And number two, the person does in fact fear the commission of an offence or engagement by the other person in conduct which is intimidatory. And number three, the conduct is sufficient to warrant making an order. So the second part of the test talks about the person's own fears. The court actually doesn't need to be satisfied that the person has those fears if the person is a child or there is a disability, or in cases of repeated domestic and family violence where they think that that person may be subject to more violence. When AVOs are made, so they can be made by a court in a number of circumstances. So they can be made by consent without admissions if the defendant agrees to an AVO. They can also be made after a plea or a finding of guilt for a serious domestic violence offence or after a hearing. Or they can be made ex parte, which means if the other party is not present, but that they were served but did not attend court. There are three stages of an AVO. The first stage is a provisional AVO. That's an order that's taken out by police. Once the police have served the other party with that, the protections are in place immediately. And then there's an interim or a final AVO. Those orders are made by a court. When the court makes an AVO ex parte, so when the defendant has not been served, they can only make an AVO in the standard conditions. And I will talk about the standard conditions a little bit later on. So these these are the matters considered by the court. So the court must consider the safety and protection of the protected person and any child directly or indirectly affected by the alleged conduct. They must consider effects and consequences on safety and protection of the protected person and any child, again, if a prohibition restriction is put in place or is not made, sorry. So that relates to whether a condition restricting the defendant from the family home is made, the effects that might have on the safety of the protected person or any child in that order. The court must consider any hardship that might be caused, particularly to the protected person, and also the accommodation needs of all parties. And again, they have a focus on the protected person and any children. The court can also consider any other relevant matter, but they can only impose conditions which are necessary for the safety of the protected person and any child, and they can't impose more than what's necessary. Okay, so we've got another poll question. If an AVO is made against someone, will they have a criminal record? So if you could answer yes or no on your screens. Okay, so we've got our results through. 23% of people said yes, they will have a criminal record, and 77% said no. And no is, in fact, the correct answer. AVOs are civil orders, so they are not criminal. However, if a defendant breaches an AVO condition, then they can be charged with a criminal offence, including the offence of breaching an AVO. An AVO does not necessarily form a part of, or does not form a part of someone's criminal record, but it can affect people applying for a working with children check, also people who may be applying to be a security guard, but they are not a part of a criminal record. So now we'll go on to looking at apprehended violence order conditions. So the standard condition, which is on every AVO, says is called a condition 1, and it says the defendant must not do any of the following to the protected person: assault, threaten, stalk, harass, or intimidate, intentionally or recklessly destroy or damage any property, or harm an animal that belongs to or is in the possession of the protected person. Now, this condition applies to the protected person and also anyone they have a domestic relationship with, and that's defined in the legislation as well. So again, it can be the children of the protected person, anyone that they live with, a family member, or if they were in a new relationship, it would apply to that person as well. This condition is just the law anyway. People can't do these things, but it is a condition on the AVO to further discourage offending of this nature. And then there are a range of additional conditions that can be added after the standard condition. So there are a range of conditions about contact. So they go condition 2 through to 6 are about contact between the protected person and the defendant. So the court will put in place what conditions might be necessary, or if the police are taking out the order initially, they will select what they think is necessary to stop further offending. So there could be a condition 2 on the order, which says the defendant must not approach or contact the protected person in any way unless it's through a lawyer. So it's a fairly strict condition, and obviously doesn't allow any contact from the defendant to the protected person aside from through a lawyer. And if lawyers are having contact with protected persons, there are a number of rules that solicitors must adhere to if they're contacting protected persons directly. They're on the website of the Law Society, but mostly that contact it should be in writing, and there are a number of other obligations on solicitors. So there's also a condition 3 that's available to the court. You sometimes see this condition when there are children listed as protected people on the AVO. So that condition 3 means the defendant must not approach the school or any place that the child goes to childcare, or any place that the protected person studies. So that one will be in place if the court or police think it's necessary to restrict the defendant from approaching these places. Condition 4 is that the defendant must not approach or be in the company of the protected person within at least 12 hours after drinking alcohol or taking illicit drugs. So you might commonly see this condition if the alleged domestic violence offending took place when the defendant was drinking or taking drugs. And this doesn't mean that the defendant cannot do that at all. They just cannot be in contact with the protected person within 12 hours. So sometimes you might see the protected person and defendant are not restricted from living, the defendant's not restricted from living with the protected person, but a condition 4 might be in place to ensure that they're not drinking or taking drugs at home or around the protected person. A condition 5 is where the defendant must not try to find the protected person. This is a tricky condition, I guess, to monitor and enforce, but you might typically see this condition when the defendant and PINOP have separated or the protected person has fled. Then there's a condition 6. So you might see condition 6 when the protected person and defendant have children together, and the court or police think that contact between the protected person and defendant needs to be limited, but that it's safe enough for the defendant to have some contact with children that they have together. So it says, condition 6, that the defendant must not approach or contact the protected person unless it's A, through a lawyer, which is similar to condition 2, but then it has a number of other exceptions. So B is to attend counselling, mediation or conciliation, or C, as ordered by a court about contact with the children. So that might be if there's family court orders in place, or D, as agreed in writing between the defendant and the parent about contact with the children. So condition D allows for the defendant and the protected person to enter into a written agreement about contact with the children. This is often referred to as a parenting agreement or a parenting plan, and it needs to be written down and signed by the two parties about contact. We can assist people draft parenting agreements. In many matters, we work with the protected person, and they may want contact between the defendant and children, and so we can assist. Instead of getting a variation to the AVO, we can assist drafting an agreement under condition 6. There's also a condition 6D, which allows a person with parental responsibility for a child to enter into such an agreement. So this might be the case where somebody else who's not mum or dad has parental responsibility for the child. Importantly, people don't have to enter into agreements under 6 just because it's there. We really encourage people to think about what's in the best interest of the child and is it safe for there to be contact under this condition. And agreements can really vary. They can have set days a week. They can allow for FaceTime or telephone calls. It's really, there is a degree of flexibility allowed by those agreements, but also the agreement is not there, the condition 6 is not there to undermine what the conditions of the AVO are. You know, that it's really focused on contact between the defendant and the children. So we'll go on to the next lot of conditions there. They're place restriction conditions. So condition 7 is where the defendant must not live at the same address as the protected person. So that means that the defendant can approach and enter the address of the protected persons, but they can't live there. Instead of that, there could be a condition 8, which said the defendant must not go into any place that the protected person lives or works. So that means that they can approach the home, you know, perhaps to pick up children or drop them off, but they can't go into the home. Or there might be condition 9 on the order, and that means that the defendant must not go within a certain number of meters from where the protected person lives or works. And commonly you would see, you know, 100 or 150 meters. At times where there are closer living arrangements or the community is much smaller, you might see less meters or a condition 8 instead of the 9. Then there's a condition 10, which says the defendant must not possess any firearms or prohibited weapons. I think if you see that on an AVO, it's a little bit of a red flag that that person might have or have had access to weapons, and that can be, I guess, a risk indicator in terms of how much danger the protected person excuse me, might be in. And then there's a condition 11. Oh, sorry, my light has just gone off in here. I might need to move and get it back on. So condition 11 allows some flexibility, and it can be drafted to allow certain types of contact. An example might be allowing the defendant to contact the protected person while they are in custody. So that might be a common one that we see. Or if the protected person's pregnant, the court may, if they think it's safe, allow a condition drafted under 11 to allow the defendant to attend the birth of a child. Excuse me. So parties can seek to vary the conditions of ADVOs, and we can give advice about this. Sorry about that. Some winter bugs going around at my house. Bridget, should we do a question? I can see some have come up.
Yeah, sure, Julia, absolutely. We have had a couple of questions come through. One is, if the defendant suddenly and coincidentally meets the protected person somewhere near the protected person's residence, would the defendant breach the AVO? Just to note that the defendant at that moment doesn't know the current address of the protected person.
Yep, so it depends on the conditions on the AVO. So if they have a condition 2, for example, then they can't approach or contact that person. Excuse me. I'll just have some more water. Hopefully that'll fix it. So if they see the protected person, then they really need to turn around and walk away, because approaching is sort of going up to and speaking to them. If there's a condition on the AVO restricting them from going with 100 meters of the protected person's residence, and they are within that, then it is a breach of the AVO. And often, if the defendant doesn't know where they live and the PIN-OP doesn't want their address disclosed, then their address won't be listed on the AVO. But often the defendant does know where they live. And if they do, then you can have the address listed on the AVO. I mean, if they it's up to police to prove that the defendant breached the AVO. So the defendant could run a defense saying, I didn't know where they lived. Excuse me. At which case the court will decide whether or not it's proved that they did breach that AVO.
Thank you. There's just someone saying they can't find information on the Law Society website about solicitors making contact when their client has an AVO against them. But I think that you said that needed to, is that one of the standard orders, or no, or was that a specific extra condition?
There's some guidelines for solicitors about how to engage complainants, and excuse me, this couldn't happen at a worse time, I don't think.
That might be a resource that we could share in the email that goes out to participants following the webinar today. So
yeah, we can send it out.
Yeah, we'll send that out, so you don't need to go searching for that now. Would you like me to continue with some questions? If the defendant is acting on their own behalf, for example, through a family court matter, how would that work under condition 2?
If there are family court orders and there's a condition 2, the condition 2 says that there's no contact from the defendant to the protected person. So the defendant cannot contact the protected person unless it's through a lawyer. So if they have a family law solicitor, their solicitor could still contact the protected person. But they would obviously need to adhere to the practice that we talked about, set out by the Law Society. If there were orders in place that allowed contact with the children, unless the orders contradicted the AVO, then the contact or the children were protected under the AVO, then contact could still continue as long as it's not breaching the AVO. The local court does have the ability to set aside family court orders if they are in conflict with an AVO, and then the matter will need to go back to the family court to be considered.
I guess each situation is quite unique that you're advising on, so it's hard to generalise at times, isn't it?
Yeah, it really depends on what the orders say. But I think if you had someone that wasn't sure about whether they were in conflict, their AVO and their family court orders were in conflict, then you would suggest they get legal advice. And we could give some advice to the protected person as well.
There's another question relating to the condition around weapons, how would that be addressed if the defendant is a police officer?
So if an ADVO is in place, then all licensed firearms that that person have are seized by police. And that applies to everybody in the same way, no matter what their profession is. Yeah.
Okay, would you like to move on to breaches, or would you like me to continue with questions?
Yep, let's go on to breaches. Hopefully we've warded off the dreaded cough. So what can you do if your apprehended violence order is breached? So there's a number of things you can do. Obviously, that as well depends on the nature and seriousness of the breach. And, you know, this is sort of general advice, but, you know, each case is different. You know, often we would encourage people to report the breach to police if that's what they want to do. Reporting to police might lead to a charge for breach ADVO and also another substantive criminal offence. It's not necessarily, like, police don't necessarily act on every breach, and they will make a decision about whether or not they think a breach has occurred and whether it's serious enough for them to act. The other option is to get legal advice, and we can provide that advice at the DVU. We can give advice on a range of things. So whether or not what happened might constitute a breach of the ADVO. And I think this is especially relevant when the behaviour is not, you know, the physical abuse that we talked about, but some of the other kind of intimidation, stalking or harassment, which might be sort of pattern behaviour and more, I guess, not as clear as an assault might be. We can also give advice on whether there might need to be a variation to the ADVO. Some people have conditions there that aren't, both parties and might not think are necessary for their safety and are providing some very practical difficulties for example, co-parenting children. And so a breach may be an indication that there might need to be a variation to an ADVO or some advocacy to police. That can be, there's a lot of laws around what can be varied and when. And so, yeah, I would encourage someone to get some legal advice if that was the case. And then again, like we talked about earlier, some family law advice. If someone protected by an ADVO has parenting orders or issues with children that need to be resolved, they might need some family law advice. Then, you know, safety planning. Obviously, if there is a breach happening, you know, are things safe or is the behaviour escalating? We know that separating is a dangerous time for many women, and I think it's a time to consider whether or not the client might need a safety plan or to revise that safety plan given a breach. And the Women's Domestic Violence and Court Advocacy Service or a social worker might be a good place to refer someone to assist with that. If people are not wanting to report it to police, then we talk about with clients, is there a way that they can document what happened in a way that's safe, you know, that's not going to be found by the perpetrator of violence? So can they take a photo of an injury? Can they make a contemporaneous note about if someone has driven past and they've seen their car? Maybe they would feel safe visiting a GP and talking to them, or making a diary note about a phone call that or an email that was a breach. And And then I think, you know, obviously it's an opportunity to engage with someone around referrals. So, you know, does this person, you know, want to link with counselling or other services? And there's a range of services out there. I'll just do a little plug for the domestic violence unit. So we offer a range of we have a range of practice areas around ADVOs, family law. We do some criminal work in the local courts, child protection. So there's a range of legal issues that often present in people's lives when, you know, an ADVO is in place. And we also have social workers and financial counsellors that work with us in the domestic violence unit. And together we can support people, you know, in a holistic way. We have some duty advice. So we are in, there's a list of local courts that we are in, and in the local courts that we are not in on a domestic violence list A, there's the domestic violence solicitor scheme. So there should be a solicitor that your client can be referred to at any local court for some advice. And also we provide some legal advice at the family court registries across New South Wales. So that's our phone number and email if you'd like to refer to us. You know, we'd be happy to give advice to any clients. There's also a lot of other great services out there, and we'll put some links to those in the information we send out.
Thank you, Julia. So
Thanks.
now we've got a bit more time for some questions, and we've got a few that came in. You've done well to struggle through with a bit of a cold happening there. So the next question is about if a vulnerable person has put in a private ADVO application that and there was a cross application from the alleged offender with their own ADVO, and the court decides to cancel both or not grant either of them protection, how does the victim submit another private application for an ADVO? The main concern is that the perpetrator is changing the narrative that they are in fact the victim.
Thanks. It's a really good question. We see a lot of this in the local court where there are cross applications, and it can be really dangerous for the protected person because, you know, not only are they sort of subject to the conditions on the ADVO, they've got this further systemic abuse around, you know, if you do this, I'll call the police, and threats of breaching the ADVO. So in that circumstance, I mean, if they've had an application refused by the court, I would really strongly encourage that person to get legal advice about, you know, often it might be a case of they haven't got their story and their circumstance across to the court in their application. So we could give them advice on whether or not we think there is merit for another application. And of course, ADVOs are one mechanism to try to keep people safe, and, you know, safety planning and other, you know, other options for people at risk of violence are also available.
Thank you, Julia. There's a question here. Do ADVO conditions have set numbers? So a firearms condition, is that always numbered 11, even if there aren't 10 conditions included before that?
Yes, the numbers that were on the presentation are the set numbers. So you might find an ADVO has a 1 and a 2 and a 9. Yeah, it's often in court you'll hear people talking in, you know, there's a 1 and a 9 or there's a 1 and a 5. So they are set the firearms one is the 10, and 11 is the sort of only condition where you sort of can draft different texts in the court. But I guess importantly for conditions, they can only say what an offender cannot do. They can't put a positive obligation on the defendant, which is often a question we get asked at court. You know, can they send him to do a men's behaviour program, or can they make him take his medication? And the answer, is no, because it's about restrictions that are needed to keep that person safe.
That's an interesting point, isn't it? Another question we have is, how long are AVOs in place for, and is there a process for them to be withdrawn?
Yes, that's a very good question. I should have said the length. I might have skipped over it as I was close to death there. So final orders are usually 2 years in length. In some matters, they count the 2 years from the first date that the AVO was taken out by police or applied for. And in other matters, the 2 years is made from when the finding of guilt is, or when the final order is made. 2 years is the standard term, but it can be shortened by negotiation, or if the court thinks a shorter AVO is sufficient. And it can be lengthened as well when there is repeated violence, or the danger is really high. There was some law reform recently which introduced AVOs that are unlimited, like indefinite, but there are specific legal tests that are required to get an indefinite AVO, and it's not common.
And so withdrawing an AVO.
So once an AVO is finalised, a party to the AVO or an interested person, so the protected person as well, can apply to have the AVO withdrawn. It's often we see a lot of applications to withdraw an AVO come through court, and actually when we talk to someone, what they might want is more of a variation, and just to have the standard condition as opposed to the whole thing being withdrawn, because the first condition is just the law anyway. It's just restating the law, so it doesn't pose any further restrictions on a defendant, and it might be more likely for someone to be able to get a variation than an AVO withdrawn, but an application can be made to withdraw to the court by either party, and then the court can consider the evidence they put before it.
Thank you. And there's a question about age. Can a young person under 18 apply for an ADVO against another young person they're in a relationship with?
Yes. There's no restriction on age on who can apply for an AVO. Obviously, there are practical difficulties, but yes, they can be applied for by a young person, or for the protection of a young person, or an adult can make an application on behalf of a child, and also so can police or someone with parental responsibility. And there are some particular legal tests that are required to change any AVOs that have children on them, and some special considerations around the safety of children who are exposed to domestic violence. So yes, there's I would encourage someone to get some advice specifically about their situation, but that's possible.
Thank you. Another question is, the audience member has a client who is breaking their no contact AVO, and they're aware of this, and they're wondering, do they have an obligation to inform police?
Do they, as in the worker or the protected person, or it's not clear?
It's not clear from the question. I'm assuming it's the protected person.
Yeah. Look, maybe I can answer both. I mean, the restrictions are on the defendant. So it says what the defendant can't do. If the protected person is contacting the defendant, we would discourage people from contacting defendants because, I mean, it can invite contact, which obviously the court or the police at some point thought that it was unsafe to have that. But also, if there is a breach later on, this material can be presented, and the police might consider it in whether or not to take action on a breach. But the protected person is not under an obligation to report a breach. And I mean, I'm not sure about what individual workers have in terms of their own organisation's obligation. Obviously, there are mandatory reporting requirements for people who are working with children, so that might be an issue. But yeah, I think in each case it's good to get some advice, some legal advice for that person. It might be that they could seek a variation if they're wanting contact, and that could be considered.
Thank you. A question about, could the defendant apply for an AVO against the protected person at the same time?
Yes, they can. So sometimes you might see cross applications that have been taken out by police against both parties, but also you might see the police take out an AVO or a private one, and then the defendant subsequently apply for an AVO. Often those matters will be listed at the same time in court, which is preferable that they're dealt with together, so because they require both parties and they might be based on the same allegation of fact. But yes, that can happen, and the court will just determine each application whether or not an AVO is needed.
Thank you. Just a couple more questions before we finish. We're just on time now. How the coercive control reforms impact this process?
Yeah, so coercive control was recently, at the end of last year, the legislation passed Parliament, and I believe it's not until next year that the reforms will take place. The legislation will be enacted to allow some lead-in time. So I guess the relationship between criminal offences and AVOs is that AVOs are considered when there has been or is a risk of a domestic violence offence, and so with coercive control criminalised, that which looks at sort of a pattern of behaviour. If that pattern is established or thought to be there, that could support the granting of an AVO. I mean, yeah, that it's a little early to tell yet, but that's sort of the initial connection I see between the two of them. Of course, that sort of understanding of patterned behaviour of control and abuse, may assist in identifying domestic violence in some matters where it might be more tricky to get an AVO in place.
Thank you. We've got some more questions coming through, but I can see that we're just about out of time. A question about whether the DVU works or assists clients who already have legal representation.
If they have representation in relation to like a family law solicitor, but they don't have any advice or they're not getting advice around AVOs, we can provide that advice. And so anyone can call us and get non-means or merit tested advice just over the phone. If they have a solicitor acting for them, often that advice might be, you know, we don't want to give a second opinion or contrary advice, and that solicitor might know their matter very well. So we might just give some sort of procedural advice or general advice for those people, but they're still welcome to call us.
Thank you. Somebody working in a school is wondering about their obligations. For instance, do they need a parent to hand in a copy of an AVO? I guess that might be guided by the Department of Education's own requirements.
Yes, I think you're right. I'm not sure what the Department of Education policy is on the matter. We would encourage anyone that we speak to where there's an AVO in place to provide the school with a copy of the AVO, particularly when there's, you know, a number 2 no contact or a number 3 about the defendant not being able to approach the school. And I guess there's what people are required to do and what might be best practice are also 2 different things. You know, we've heard clients talk to us about, you know, that children might not be listed as a protected person on an AVO, but, you know, have their own fears about the defendant. And if they're turning up to school and that child is fearful about going home with them, you know, I've heard of stories of them contacting the other parent or like asking the child to stay in the class. So yeah, it might be, it depends on, I guess, you know, what your own obligations are, but certainly, you know, if there's an AVO in place, it would be ideal to have a copy of it. Yeah.
Thank you. We've got to, I'll just ask this final question. The rest is thank you and people saying well done for powering through. A question about the weapon condition. Is it generally applied anytime the defendant has access to a weapon, and how might that be balanced against their need to support themselves and their children? So if they were a police officer.
It's applied, I think, when the police are aware that the person has a firearm license or access to it, or even it talks about, I mean, obviously there are some firearms that aren't licensed, and even if you often see that condition on there, if the defendant has mentioned access to a weapon. If the defendant is able to apply to the court at any point during the AVO to seek a variation on the conditions of the AVO. There is a specific, if children are listed on the AVO, then it can be more tricky to get a change, and that's because, you know, the children aren't at court. They're not necessarily they're represented, and obviously the court is wanting to ensure the safety of any children involved in a relationship. But yes, if it's impacting, if any of the conditions are impacting on someone's livelihood, then they might get their own legal advice and seek to vary the condition. Yeah.
Thank you. We've gone a little bit over time so that we could answer those questions. I'd like to thank our audience and thank you, Julia, for absolutely powering through given what you're struggling with, and thank everybody for their questions and their engagement. Just to let you know that this webinar is recorded and it will be available on the Legal Aid New South Wales YouTube channel after today. So thank you, everybody, and we'll end the webinar now. Thanks so much, Julia.
Thanks,
Bye,
Bridget.
everybody.
Thank you, everyone.